Hello and welcome. For those of you that don't know me, my name's Sarah Ash and I'm an employment partner at Walkers in Guernsey, and I'm going to be presenting this session today along with my colleague Danielle Bruard, who's one of our senior counsel in our employment team. Today's session is the second course in our suite of training modules, and today we're going to be looking at the introduction to the new Discrimination Ordinance. So what we're aiming to cover today is the existing discrimination legislation landscape in Guernsey. We'll look at the new protected grounds that the new discrimination ordinance is introducing. We'll cover the different types of discrimination and also other prohibited conduct set out in the legislation. We'll look a little bit at who the new legislation applies to. Then we'll move on and cover the procedure for bringing claims. And finally, we'll look at remedies and awards. Firstly, I just want to cover off who the Consortium are. So the lead partners in the Consortium are Walkers and the Guernsey Institute. And then we have supporting partners, Equality Guernsey, Focus HR and the Guernsey Employment Trust, GET. And we're all working together to bring this suite of training. So moving on to look at the existing discrimination legislation in Guernsey. We currently have the Sex Discrimination Employment Guernsey Ordinance 2005, and this piece of legislation prohibits discrimination on the grounds of sex, marital status and gender reassignment. It was extended in 2016 to cover maternity and adoption leave. And importantly, this piece of legislation applies in the employment context only, and I'll come on to describe in more detail in a moment how that differs to the new discrimination ordinance. So, under the new discrimination ordinance, we will see protection extended to other protected grounds, and there are 5 of them that will be introduced on the 1st of October 2023. These grounds are disability, carer status, race, religion or belief, and sexual orientation. There is also a proposal to add age and expand protection against sex discrimination at a later date. We're still awaiting policy details on these, but we could expect that these may be introduced no less than 2 years after these 5 grounds set out on the slide. So who needs to comply with the new discrimination ordinance? Well, employers, it's going to be relevant for employers as the current existing legislation is. But as you can see from this slide, the new ordinance will be far wider reaching than the sex discrimination ordinance, which is limited to the field of employment only. Some of the key additional groups who need to be aware of their obligations under the new ordinance are providers of goods and services, accommodation providers, schools and education providers, and clubs and associations. It will also extend to charities and voluntary groups. Of course, it's really important that employers will also need to be well prepared in advance of the new legislation coming into force, as they will have new protected grounds to consider which will impact their policies and procedures and be relevant right from the start of any kind of employment relationship, from the recruitment process throughout the life cycle of that employment relationship up until the termination of employment. We're going to come on in our later sessions to talk about the specific obligations of employers under the legislation and employers' responsibilities in session 3. And we'll also cover some of the specific obligations on service providers in more detail in session 4. As I'm sure you're aware, we're also running a session on reasonable adjustments and accessibility, and that will be covered in session 5, as we know this is a topic of real interest to everyone. So looking at the new ordinance itself, this draws on some of the concepts that are already in the Sex Discrimination Employment Guernsey Ordinance and also in existing Great British and Jersey legislation. So some of the concepts will be familiar to those of you that are familiar with our existing legislation. As I've mentioned a moment ago, the new discrimination ordinance will come into effect on the 1st of October 2023, although there will be some exceptions to this. So duties will not apply to education providers before 1st of September 2025. any duty to make changes to physical features of premises will not come into effect before 1st of October 2028, and the public sector duty to prepare access audit plans will not come into effect before 1st of October 2028. Now, despite the fact that there is a delay in some of these provisions coming into effect, all businesses are encouraged to take advantage of the lead-in time to prepare and to start to make changes in line with best practice. So, for example, any business planning to move location of their office or premises, or that may be planning refurbishment, if you find yourself in this situation, it would be advisable to consider if there are any physical features that you may want to change or introduce so that these can be factored into your plans. We're now going to come on and talk about protected grounds, and I'll hand over to Danielle at this point.
Thank you, Sarah. So in this section, we're going to look at the new protected grounds and how each of them is defined under the new ordinance. The new protected grounds are set out on this slide: disability, carer status, race, religion or belief, and sexual orientation. So let's start with disability. And I think it's fair to say that this is one area of the ordinance that attracted a lot of interest and feedback during the consultation process. And there were some changes to the definition made along the way. But where did we end up? Well, a person has the protected ground of disability if they have one or more long-term impairments. So if we break that down a bit, what will a long-term impairment be? Well, it's an impairment that has lasted or is expected to last 6 or more months, or until the end of the person's life. And the ordinance makes it clear that it can include conditions which are in remission if they have the potential to recur. So, for example, if someone has had something like cancer or arthritis, which has lasted less than 6 months, but has the potential to recur in future, it will be covered, it will be considered long-term. Equally, it can include conditions which are controlled by medical treatment. So that would be things like diabetes, potentially. The fact that the definition includes the words "is expected to last" means that a person does not have to wait until they've had a condition for 6 months in order to be protected. They can have a disability for the purposes of the ordinance from day one of having a condition, provided that it is expected to last for not less than 6 months. That's long term, but how is impairment itself defined? I've set out on this next slide the definition from the ordinance, and I'll just give you a few seconds to read through it. So as you can see, the definition of impairment itself is very wide, and it will include pretty much any physical, mental or other medical condition that a person may have. Those of you who are familiar with discrimination law in Great Britain or in Jersey may be familiar with the concept of a disability having to have a substantial adverse effect on someone's ability to carry out day-to-day activities or similar. There is no equivalent requirement under the new Guernsey Discrimination Ordinance. Provided that someone has an impairment which is long-term, they will be considered to be disabled for the purposes of discrimination law. Now, of course, this does not mean that the impact of someone's impairment or lack of impact has no effect on an employer or service provider's duties under the new ordinance, because the severity of or the lack of any impact will become relevant when an employer or other person is looking at, for example, whether they need to make reasonable adjustments. Who decides whether the definition of disability is met? Well, it's a question of fact, and in many cases it may be obvious whether or not someone is disabled, but where the position is unclear, medical evidence may be sought. Moving on to carer status, a person has carer status if they provide care or support on a continuing, regular or frequent basis for a person with a disability, and the disability is of a nature which requires continuing, regular or frequent care or support of that kind. Now, importantly, the person caring and the person being cared for also need to be either close relatives or live together. And the definition of close relative for these purposes is set out on this slide. So anyone caring, for example, for a neighbour or a friend will not have carer status for the purposes of the new ordinance. And likewise, someone caring for their own children, for example, will not be a carer unless the children have a disability which requires continuing, regular or frequent care or support. The ordinance also makes it clear that those who provide support or care in a professional capacity will not have carer status. However, this does not prevent someone being reimbursed for their expenses. So if someone is caring, for example, for an older relative and incurs expenses driving them to appointments or to do shopping or something like that, they could be reimbursed for their petrol money without this taking them outside the scope of carer status under the new ordinance. The ordinance also confirms that people who are foster carers or adopters are covered by carer status. As with disability, there may be a need for medical advice on the issue of whether someone's disability requires continuing, regular or frequent care or support of the kind that they're providing. And then finally, just another comparison with Great Britain and Jersey law. So in both of those other jurisdictions, carer status is not a protected ground. So this is something that is unique to Guernsey law insofar as being a protected ground in itself. However, in those other jurisdictions, carers are sometimes protected through other types of claims, for example, indirect sex discrimination or discrimination by association. Moving on to race. Race covers all the things set out on this slide. So colour, nationality, national origins, ethnic origins and descent. So if someone is discriminated against on any of those grounds, they will be considered to have been discriminated against on grounds of race. The ordinance also specifically makes it clear that national origin includes being of bailiwick origin. All racial groups are protected under the new ordinance, including white people. You do not have to be from an underrepresented group in order to be protected. And a racial group can be made up of two or more distinct racial groups. So, for example, if someone is discriminated against on the basis that they are of South Asian origin, they would have a claim under the ordinance, even though the term South Asian could be broken down into more distinct racial groups. Racial groups can also be defined by exclusion. So, for example, if someone is treated less favourably than someone else because they're not from Guernsey, then they would equally have a claim under the new ordinance. Next, we have religion or belief. Now, this is one area of the ordinance which did change during the state's debate at the end of September. The protected ground was originally religious belief, but the states agreed to extend this to cover other secular beliefs. The wording of this part of the ordinance now essentially mirrors the equivalent wording in Great Britain. And so when looking to how to interpret this protected grounds, our tribunals are likely to find case law from Great Britain to be very persuasive. So what is likely to be a religious or philosophical belief that's protected under the new ordinance? Well, in Great Britain, the tribunals looked to the case of Nicholson and Granger, where the British court set out a 5-part test in determining whether a religion or belief should be protected. And I've set out that test on this slide. It includes things such as, is the belief sufficiently serious and cogent and worthy of respect in a democratic society? So in terms of religious beliefs, both mainstream and less common religious beliefs will be protected, provided they fulfil those criteria. And a lack of religious belief is also covered. So atheists and humanists, for example, would be protected from discrimination. As I've already mentioned, though, this protected ground goes beyond religious belief and covers other secular beliefs. And in Great Britain, the types of beliefs that have been found to be covered by this protected ground include things like a man-made belief in climate change, anti-fox hunting, ethical veganism, and gender-critical beliefs. At the other end of the scale, the tribunals have found that things like support of a football team are not sufficiently serious to be protected. In terms of a comparison with Great Britain and Jersey law, as I've already mentioned, British law is the same as our New Guernsey law in this respect. But Jersey law is different in that there's no protection there on grounds of either religion or belief. And finally, sexual orientation. This is defined as a person's sexual orientation towards persons of the same sex, persons of a different sex, or persons of both the same sex and a different sex. And now I'll pass back to Sarah.
Thanks, Danielle. So we're now going to move on and look in this next section about types of discrimination and other prohibited conduct. So firstly, I'm going to cover direct discrimination. This concept may be familiar to those of you that have experience with the Sex Discrimination Ordinance already, but this in essence is where you would treat someone less favourably than you treat or would treat others because of a protected ground. And it's important to note that the protected ground does not have to exist at the time of the less favourable treatment. So an example of direct discrimination might be refusing to serve someone at a restaurant because of their race, or refusing to hire someone because of their religion. I just got some further examples here because direct discrimination can be based on a protected ground someone had in the past but no longer does. And an example here might be a landlord refusing to rent accommodation to someone because they had a mental health condition in the past. It may also be based on a protected ground that someone may have in the future. So, for example, here it could be failing to promote someone due to caring responsibilities that you think they may end up having in the future. And finally, an example of direct discrimination could be that it's based on a protected ground that a person may be perceived to have, even if they do not. So an example here might be refusing to allow someone to become a member of a club because you believe them to be gay. A person who brings a claim for direct discrimination needs to be able to point to someone else, and that's typically referred to as the comparator. And that's someone who has been or would be treated more favourably. And the comparator needs to be someone who is in materially the same circumstances. In addition, the less favourable treatment must be because of the protected ground. So a person seeking to bring a claim of direct discrimination needs to be able to compare themselves to another person, whether real or hypothetical, and show that the other person has been or would be treated more favourably than them. So an example here might be in a scenario where a company had a head office in the UK and they decided to second a limited number of staff from the UK to work in their Guernsey subsidiary alongside locally recruited staff. In this scenario, one of those local workers complains that his salary and benefits are lower than those of a secondee from the UK who's employed at the same grade as him. Now, in this situation, although the two workers are working for the same company at the same grade, the circumstances of the secondee are materially different. He's been recruited in the UK, has had a different career path, and his salary and benefits reflect the fact that he's working abroad. And so for these reasons, he would not be seen as a suitable comparator. if the Guernsey-based employee could point to somebody else in Guernsey on the same circumstances as him and at the same grade, then there may be that may give rise to a situation where there may be a fair comparator and an example of direct discrimination. It is not directly discriminatory to treat a person without a disability less favourably than someone with a disability, and that's assuming that the person with a disability has been treated more favourably for the purposes of removing or mitigating a disadvantage, and the same applies in relation to carer status. So an example here might be if an employer could decide to offer all disabled applicants a guaranteed interview, and a non-disabled person could not claim that this in itself is discriminatory. Moving on now to discrimination by association. This is where you're treating someone less favourably than you treat or would treat others because of their association with another person. And this would be in circumstances where similar treatment of that other person would constitute direct discrimination, for example, due to their association with a family member, partner or friend. So an example here might be where a manager treats a worker who is heterosexual less favourably because she has been seen out with a person who is gay. Now, I'm going to cover indirect discrimination. This is where applying a provision, criterion or practice, sometimes referred to as a PCP, which puts those who share a protected ground, including the specific individual in question, at a particular disadvantage, and which cannot be justified as a proportionate means of achieving a legitimate aim. So what does that mean? I'm now going to break that down and we'll look at the definition in parts. So first of all, what is a PCP? So this would include, for example, formal or informal policies, rules, practices, arrangements, criteria, conditions, qualifications or provisions. It can also include one-off discretionary decisions. And a PCP will, on the face of it, appear neutral. It's applied to everyone in the relevant group. So a classic example in the employment context is an employer requiring an employee to work full-time. Now, this requirement could disadvantage women as a group, since women in society as a whole bear a greater part of domestic and childcare responsibilities than men, and they're more likely to want or need to work part-time. Now, unless the employer could objectively justify the need for a full-time worker to do the job, the requirement might well be indirectly discriminatory against a woman with childcare responsibilities. Now, as I mentioned, for there to be indirect discrimination, the PCP must put those who share a particular protected ground at a particular disadvantage. So who are the persons who share a protected ground in relation to a disability? People who share a particular disability, so for example, not all people with disabilities. And how does a claimant show that those who share a protected ground are placed at a particular disadvantage by the PCP? It might be obvious. If a particular disadvantage is less clear, then you should be considering statistics or medical evidence in these situations. So I'll talk you through some examples now to bring this a little bit more to life. So, for example, a retailer might accept only online job applications without offering these in alternative formats. This could disadvantage applicants with learning difficulties who have limited computer skills, or applicants with a visual impairment who may rely on software that isn't compatible with an employer's application portal. Another example might be a cafe, whereby to attract new customers, a cafe owner offers a 10% discount to any customer who can show that they've lived in the bailiwick for the past 10 years. This clearly places people who are not from the bailiwick at a particular disadvantage. Or, for example, a shop who requires all employees to work on a rota system, which includes some Saturday shifts. This may place Orthodox Jews who are unable to work on the Sabbath at a particular disadvantage. And when we're considering indirect discrimination, as I've mentioned, not everyone who shares the particular ground needs to be put at a disadvantage, but it is important that the claimant themselves must be put at the disadvantage. So in the previous cafe example, it does not matter that some people from other countries will have been here over 10 years and be entitled to the discount. So another example here, if an employer refuses to allow any of its roles to be carried out part-time, this could place a number of groups at a particular disadvantage, including women, carers, and those with certain disabilities. It does not matter that some women, carers, and disabled people are able to work full-time. If the percentage of women who can do so is significantly lower than the percentage of men, then the requirement to work full-time will, on the face of it, be indirectly discriminatory. Moving on now to objective justification. If a person applying a PCP can show that operating the PCP is a proportionate means of achieving a legitimate aim, then their actions will not amount to indirect discrimination. This is known as the objective justification test, and it also applies in other areas of the Ordinance. It is up to the duty holder, so for example the employer or the service provider, to demonstrate objective justification. So looking in a little bit more detail at objective justification, there is a two-stage test. First of all, you need to think about whether or not the aim of the PCP is legitimate, and if so, is the means of achieving it proportionate? So what is a legitimate aim? Well, it must be a real and lawful aim, and it cannot be based purely on cost. And when looking at whether the PCP is proportionate, you must consider, is there a less discriminatory way of achieving the same aim? So, for example, a food manufacturer has a rule that those preparing food cannot have beards. This rule may amount to indirect discrimination against Sikhs or Muslims. If the aim of the rule is to meet food hygiene or health and safety requirements, this will be a legitimate aim. However, the employer would need to be able to show that the beard ban is proportionate and that the risks could not be managed in a less discriminatory way. So, for example, requiring those employees with beards to wear beard masks. Another example may be a role which requires overseas travel. This could impact carers and possibly other groups. It may be a legitimate aim and there may be no way around it. Or there could be other steps that could be taken. For example, could meetings be carried out remotely, for example? I'm now going to hand over to Danielle to cover some further types of discrimination and other prohibited conduct.
The next type of discrimination we wanted to cover is discrimination arising from disability. And this occurs where a person is treated unfavourably because of something arising in consequence of their disability. And this is most likely to arise in situations where someone's performance or behaviour is impacted in some way by their disability. Like indirect discrimination, discrimination arising from disability can be justified, and so the same objective justification test applies that Sarah has just mentioned. To give an example of potential discrimination arising from disability in the employment context, say you have an employee who perhaps has been performing well and then their performance starts to dip. They start making mistakes, perhaps they start coming in late, and they end up being disciplined for this. If the reason why their performance has dipped relates to a disability, then this will be unfavourable treatment, which arises in consequence of their disability. The employer would then have to look at whether they can objectively justify their decision to discipline the employee. And this would involve looking at all the facts and circumstances, including, for example, did the employer know or should they have suspected about the disability? And we'll come on to talk a bit more about that in a minute. How long were the effects on this disability likely to last? Were there any alternatives that could have been explored? Maybe alternative treatment that could have been considered, or alternative roles that the employee could have carried out. In these situations, medical advice is often key. Moving on to the duty to make reasonable adjustments. I'm not going to say too much about this now, because as Sarah has already mentioned, we have a whole section on the duty to make reasonable adjustments, which will be session 5. For now, I just wanted to run through what the duty is. So the duty to make reasonable adjustments applies where a provision, criterion or practice, that's the same definition of PCP that Sarah's already run through, or a physical feature of premises, or the lack of an auxiliary aid, which would be something like specialist equipment, puts a disabled person at a substantial disadvantage in comparison with people who are not disabled. And where any of these things apply, the person with a duty under the ordinance must take reasonable steps to avoid the disadvantage or to provide the auxiliary aid. And the whole aim behind this duty is to ensure that disabled people have access to the same opportunities and the same services, so far as is possible, as someone who is not disabled. Some examples of potential reasonable adjustments would be things like a cafe allowing service users to bring in assistance animals if that is something they require, or providing specialist equipment in the workplace, or perhaps allowing someone to book your services in a different way. If a request for an adjustment is made by a specific employee or user of your services, it is always a good idea to discuss this request with them, consider medical advice perhaps in the employment context, and respond to the employee as to whether or not you can carry out that adjustment and the reasons why not if you can't. But on top of that kind of reactive duty to make reasonable adjustments where requested, service providers, education providers and schools have an additional proactive duty to make adjustments that their service users and students might require. And as I said, we'll come on to cover this in much more detail and what it means in practice in session 5. The duty is only to make adjustments if they are reasonable, and what is reasonable will depend on all the circumstances, including the nature and size of the business, whether or not the adjustments requested will even be effective, and of course, cost. As I said, this topic will be the focus of session 5. I briefly mentioned before that whether or not the employer or service user has knowledge of disability is often relevant. It is relevant, for example, in discrimination arising from disability and the duty to make reasonable adjustments, as no liability will arise for either of those two things if the person or organisation didn't know and shouldn't have been expected to know that the person had a disability. It's really important to remember, though, that employers and service providers cannot avoid liability by failing to make reasonable inquiries. So in the example I gave before of an employee who had been performing very well and whose performance dips, it's probably that's probably enough kind of evidence for the employer to have been making reasonable inquiries as to whether or not there was something going on there in terms of an underlying medical condition that might have been affecting the employee. and the employer cannot avoid liability by failing to ask those questions. If someone in the organisation, for example, a member of HR, knows that an employee has a disability, but others in the organisation do not know, knowledge may still be kind of imputed to those people. So, for example, if a manager is going through a performance management or redundancy or any other type of HR process with an employee, the fact that that particular manager did not know about the disability might not necessarily be a defence, because there should be mechanisms within the company for sharing information that is known by others where appropriate to do so. But obviously, when deciding upon this, the organisation must bear in mind its obligations of confidentiality and data protection, and not share the information any more widely than it absolutely needs to. Moving on to some other types of prohibited conduct, the next type of prohibited conduct I wanted to discuss is harassment. And I have set out on this slide the legal test for harassment. And that is where someone engages in unwanted conduct, which is related to a protected ground or of a sexual nature, and has the purpose or the effect of violating another person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. So if we break that down, as we've done for some of the other types of discrimination, firstly, what is unwanted conduct? Well, it covers a wide range of behaviour. It could include anything that someone says, something that someone does, and even things like sharing images. It can include one-off incidents. So the victim does not have to have expressly objected to conduct once and it have happened again for it to constitute harassment. Conduct must relate to a protected ground, but it doesn't necessarily have to be a protected ground that the victim possesses. So, for example, if someone is subjected to homophobic name-calling, that can amount to harassment, even if the people carrying out the name-calling know that the victim is not gay. And likewise, if someone makes an offensive remark about people of a particular religion, that can constitute harassment of people who overhear that remark, even if they do not share the religion, the relevant religion. Conduct will have the necessary effect if the victim considers it to have that effect and it is reasonable for it to do so. So the test there is part subjective and part objective. And then finally, there is another type of harassment, which is where somebody engages in harassment, and then because of someone else's either submission to or rejection of that harassment, they are then treated less favourably. So an example of that would be if you've got a landlord who makes sexual advances towards one of their tenants, and those are unwelcome, and the tenant says they're not interested. If the landlord was to fail to renew the lease because the tenant had rejected their advances, that would equally be harassment under the new ordinance. Victimization is where someone is subjected to a detriment because they have made a complaint under the ordinance, supported someone else's complaint, or done anything else under the ordinance. So that could be something like challenged an internal policy decision which they believe would contravene the ordinance. Or it could be that a person has not done any of those things, but the employer or service provider or other person suspects that they have done or will do so. The complaint under the ordinance that the person needs to have made or supported does not have to be against the same organisation which is found guilty of victimisation. So, for example, if an employer decides not to hire a new employee because they find out that that person has previously brought a complaint of discrimination against a previous employer, that would still constitute victimisation. And then finally, I just wanted to touch on a few other types of prohibited conduct. Firstly, a person must not publish or cause to be published an advert which indicates or might reasonably be understood as indicating an intention to breach the new ordinance. Also, a person must not instruct or induce someone else to breach the ordinance, because that in itself is an example of prohibited conduct. And then finally, an employer must not provide different pay or terms and conditions to employees who are carrying out similar work if the reason for that difference is tainted in any way by discrimination. And this is something that we'll come on to cover in much more detail in session 3. I'll now pass back to Sarah to go through some of the exceptions in the ordinance.
Thank you, Danielle. So I'm going to now move on and talk about some of the exceptions that are set out in the new discrimination ordinance. The first one I'm going to cover is positive action. Now, it is possible to take certain actions with the aim of ensuring equality or a greater degree of equality on any of the protected grounds. This does not extend to giving preference in recruitment or promotion to someone from an underrepresented group unless they are equally qualified for the role. So, for example, if an employer had 2 candidates who in all ways were equal in terms of qualification, experience, and were both equally well suited for the role, but one of the candidates was black, all else being equal, if minorities are underrepresented within the organisation, that employer could choose to take the positive action of offering the role to the black candidate. We're now going to show a short video to illustrate positive action.
We signed up to the Charter because we have a diversity and inclusion strategy, and we are trying to ensure inclusion for all. And we recognise that there is a portion of the community that potentially is not able to be included. And we were really impressed with the work that the Guernsey Employment Trust has been doing to help people with either hidden disability or a physical disability to enter the workplace. So that's primarily the reason that we decided to sign up to the Charter. The first thing we did was we included it within our recruitment policy. The second thing we did was invite our managers to training so that they were aware of our intention to sign up to the Charter, and also to ensure that we offered an interview to anyone that met the minimum criteria. So this then has enabled people to gain that interview that they may not otherwise have had. I think it's given more people to have that first interview because I don't think some of those people would have been registered with agencies, either because they didn't have the confidence or they didn't have the experience to become regular candidates. So I think by Guernsey Employment Trust having that bank of potential candidates, then essentially we've seen people that we would not otherwise have interviewed. We're not looking at apples and apples because the people need that little bit of extra help to get over the line, and this enables them, I believe, to be on an equal footing with those that are more able able-bodied or haven't or have some form of hidden disability.
Moving on to another exception. This one's freedom of expression, and this was a new exception which was introduced following the recent states debate on the 30th of September. And this is where expressing an opinion or view on any subject does not by itself constitute an act of discrimination. However, a person cannot rely on this exception in relation to any claim for victimization, and in relation to claims for harassment, the exception only applies if the individual expressing an opinion did not intend to harass anyone, and it would not have appeared to a reasonable person that their conduct would violate the dignity of anyone else or create an intimidating, hostile, or degrading, humiliating, or offensive environment for them. So to take an example, if a person were to express a view that a woman should have the right to choose whether to proceed with a pregnancy or whether to opt for an abortion, a person who is offended by this viewpoint, whether for religious or other reasons, cannot claim that it amounts to harassment, assuming that the person expressing the view did not make the statement to deliberately offend or upset, and provided that a reasonable person would not have expected the statement to have that effect. This exception may in some cases prove helpful to employers, although there is of course scope for disagreement as to whether a reasonable person would have expected a particular viewpoint to upset or offend others. It's also worth noting that this exception is limited to the expression of views and not any actions that may be taken in consequence of those views. Set out on this slide are some other exceptions which are set out within the legislation, and I'll touch on a couple here. So, for example, the implementation of population management. This exemption applies to the protected grounds of race and carer status. Implementation of the immigration policy. This exception applies to the protected grounds of race, disability, carer status and religious belief. And for example, for tribunal members, this ordinance does not prohibit a member of the tribunal from taking any action which is done in the exercise of functions exercisable under, in connection with, or for the purposes of the Employment and Discrimination Tribunal Guernsey Ordinance 2005. Now, we will also come on and talk about some more exceptions in each of Session 3, which is employers' responsibilities, and Session 4, which is for service providers' responsibilities. And we'll talk about some of the more relevant exceptions in those contexts in our later sessions. I'm now going to move on and look at the complaints procedure and the tribunal process itself. So set out on this next slide in a sort of flowchart format is the process and procedure that would be followed if someone were to have a complaint. And I'll come on and talk about these different stages in a little bit more detail in a moment. But just to see, as you can see from the slide, there are various routes that will be followed where a complaint is not resolved, but there are also various points in the process where complaints may be resolved, which will draw an end to the process. In addition, I think it's important to just to flag that at the very top of the slide where we talk about notifying potential respondent about a complaint, just to flag this is not applicable for complaints against employers. And although no initial notification is required in the employment context, I would just point out that in practice, employees would usually raise concerns under the applicable internal company process, such as a grievance process, before they got to the stage of contacting the Employment in Equal Opportunity Service, which is EEOS. And this should be encouraged as an early means to resolve potential complaints. Once a formal complaint has been made, There are, of course, a number of things that can happen. It may proceed all the way through to a tribunal, but there are a number of ways that it could end sooner. For example, the claim may be struck out or settled through post-complaint conciliation. So although this slide stops at the formal complaint being made to the Employment and Discrimination Tribunal, that doesn't necessarily mean that at that stage the automatic end result is a hearing. There may still be opportunities to resolve the complaint before ending up in the tribunal. So I'm now going to break down this process a little bit further. So the initial notification of the complaint, as I said, this applies only if a claim is brought against a provider of goods or services, a provider of education, a provider of accommodation, or a club or association. So it's not for employers. So if somebody wanted to make a complaint, the complainant must notify the person who the complaint is about within 6 weeks of the act complained of. So there's a relatively short time frame here. The complainant must do this in writing, so that complaint needs to be put forward in written format. And it must state that if the potential complaint is not resolved within 1 month, they may exercise their right to make a complaint under the ordinance. So given these short time frames and this requirement for a written complaint, it is very important that if a complaint is received, that this is dealt with promptly. Of course, if following receipt of a complaint that matter is resolved, then the process will conclude at that point. However, I'll now look at what will happen if a complaint is not resolved at this early stage. So, moving on to pre-complaint conciliation and time limits. So before filing a claim, the complainant must notify the Employment and Equal Opportunities Service, who will give both parties the chance to engage in pre-complaint conciliation. Now, it is important to note that at this point, clearly, if one party was not willing to enter into that pre-complaint conciliation, the process would need to move on at that point. However, it is possible that matters may be resolved through pre-complaint conciliation, and if so, that would be the end of the process. But if pre-complaint conciliation is unsuccessful, then a complainant must then file their complaint, and this normally must be presented to the tribunal within a period of 3 months of the act complained of. However, any period of conciliation that the parties have entered into, even if this then breaks down, that will not count towards that 3-month time limit. And it's important to note as well that the tribunal does have discretion to extend the 3-month time limit where it is satisfied that it was not reasonably practicable for the complaint to be presented within the 3 months, or that it is just and equitable to extend time. In addition, if that 3-month time limit would have otherwise expired during the conciliation period or within the following month, the complainant will have until at least 1 month post-conciliation to bring their claim. So, bringing a claim before the tribunal. Claim forms and response forms will be available on the Employment and Equal Opportunities Service website, and there obviously will be specific forms that a claimant will need to complete if they wish to bring forward a complaint. And whilst each claim will turn on its own facts, it may be possible to resolve matters through post-complaint conciliation, and in some circumstances, as I've referred to earlier, the tribunal may determine that the claim should be struck out, which would end the process. However, should the claim proceed forward, it would move forwards to a hearing. If you reach that stage, during the hearing, the complainant must prove facts from which the tribunal could conclude that a breach of the ordinance has occurred, in the absence of an adequate explanation from the respondent. If they prove this, then it is for the respondent to prove that they did not breach the ordinance. Depending on the outcome of the tribunal, there are potential for appeals from either party to the Royal Court and then the Court of Appeal. And that's similar to the process that we currently have in place. I'm now going to move on to cover awards and remedies under the new discrimination ordinance. And I think at this point it's important to flag that this is one section of the new discrimination ordinance which will apply to our existing sex discrimination ordinance as well. So this is one part of our existing legislation that will be changed and will be consistent with the new discrimination ordinance with effect from the 1st of October 2023. In addition, when thinking about awards and remedies, this also includes financial and non-financial awards. So, for example, orders to make a reasonable adjustment, for example. So, looking at remedies, and I'm first going to look at financial awards for work cases other than equal pay. So, in this situation, a successful claimant may receive up to 6 months' pay for any one complaint, or up to 9 months' pay for joined complaints relating to the same facts and circumstances. And that's whether those claims are joined with unfair dismissal, a complaint under the Sex Discrimination Ordinance, or another complaint under the new ordinance. So, for example, it may be an unfair dismissal claim and a claim for race discrimination, and that would see a cap of up to 9 months' pay in that instance. Or it might be a complaint of race discrimination and sex discrimination arising and relating to the same facts and circumstances, and again, that would be capped at up to 9 months' pay for those joint complaints. Now, there is a difference here because our existing legislation, if a successful sex discrimination claim were to be brought in the tribunal, the award there would be a sum equal to 3 months' pay. So we can see that there is an uplift here, but also that the tribunal has some discretion because it's no longer a sum equal to, it's up to 6 months' pay. So there may be some discretion there in terms of the level of awards that we see. In addition, an award for injury to feelings, hurt or distress may be brought, and this is up to an additional £10,000 sum. And I'll come on in a later slide to talk a little bit more about these types of awards. Another point which is important to note is that victimization will not fall within the overall cap. It will be seen as a separate head of claim and therefore treated with a separate award or remedy. And this may attract an additional award of up to 6 months' pay. So somebody may be able to bring a claim for race discrimination, and if successful could receive up to 6 months' pay for that one complaint. And if they were also subjected to victimization in relation to their race and because of an act that had occurred, they may also be able to attract an additional award of a further 6 months' pay in that instance. In addition, as you can see on the slide, I've also noted equal pay. Now, clearly this comes into effect from the 1st of October of 2023, and it may be possible for somebody that brings a successful equal pay claim to receive up to 6 years arrears of pay. However, this will only start from the introduction of the new legislation, so you can't look backwards or count any situation currently. It will be looking forwards from the 1st of October 2023 and for claims that may be brought from that period of time. So moving on now to look at financial awards for non-work cases. So in these situations, the tribunal will be looking at financial losses of up to £10,000. Now, there may be instances where somebody may not actually suffer a direct financial loss. And so there's also the ability to claim for or make a claim for injury to feelings, hurt or distress. And that may again be an amount up to an additional £10,000. Again, I'll come on and talk a little bit more about how those injury to feelings awards may be determined in a moment. If 2 or more complaints are joined, the above caps will still apply, unless one of the claims is for victimisation, in which case this may give rise to an additional award. And so an additional award for victimisation would be up to a further £10,000 plus a further £10,000 award for injury to feelings, hurt or distress. Financial awards against employment agencies, vocational training providers, partnerships, those who appoint others to personal or public offices, and professional organisations. In these cases, the same method would be followed as for work cases, unless this basis of calculation is inappropriate. So, for example, because the complainant does not receive pay or have a usual amount of pay, in which case compensation will be calculated in the same way as for non-work cases, so looking at financial losses and also considering injury to feelings. So moving on to the Injury to Feelings Awards, this is a new award that's being introduced. We don't currently have this under our existing legislation. And this is an award to compensate for the effects that the Discriminatory Act has had on a particular complainant. Now, you can see from the slide that this is yet to be affirmed by the states, but the Committee for Employment and Social Security intends to recommend 3 bands. And this will be what the tribunal, if approved by regulation by the states, the bands that are being proposed, the lower band will be £500 to £3,000, the middle banding £3,000 to £6,000, and the upper banding will be £6,000 to £10,000. So you can see there is some discretion there for the tribunal to consider what level of award is appropriate in the circumstances. And the size of the award will take into account factors such as the degree of hurt and distress or upset caused, the seriousness of the treatment, and whether the discrimination was a one-off incident or a course of conduct. But it should be noted that in some situations, if deemed serious, very serious, a one-off incident could attract an award within the upper band. Awards may be reduced if the complainant unreasonably refuses an offer by the respondent, which would have put them in the position they would have been in had the discrimination not occurred. In addition, as another remedy, the Employment and Equal Opportunity Service may also serve non-discrimination notices requiring the recipient to cease discriminatory practices, which, if not complied with, may lead to a financial penalty being put forward. Now, this would not be dependent on tribunal proceedings being brought, so the EEOS could make that determination itself, and there will be a register of non-discrimination notices, and that will be maintained and will be available for inspection. So this will still cover some reputational risk for businesses. So finally, I just wanted to cover some measures that are being introduced to support the introduction of the new discrimination ordinance. I think important to note is that there will be the introduction of legally qualified chairs for tribunal hearings, and given the complexity of the new legislation and the fact that we will, certainly for a period of time, have 2 discrimination ordinances in play, I think it would be very helpful that we have legally qualified chairs coming in for the tribunal hearings to navigate through this new discrimination legislation. In addition, we'll see the introduction of tribunal rules of procedures, which will provide more of a framework and streamline the tribunal process. I've mentioned quite a bit EEOS, and I think the establishment of the Employment and Equal Opportunity Service will, of course, be a great support to people for the introduction of this new ordinance. And it will enable both parties or anyone that has questions to be able to ask them of that service. In addition, another important measure that is being currently prepared are the guidance notes for employers and service providers, and those will set out examples similar to those that we've talked about today and give further guidance on the steps required under the new discrimination ordinance.